Okay, so I believe I've covered the drawing slides. So we have a question from a live webcast viewer. I found it convenient to define the article or as being inclusive. In the absence of a definition, the courts have construed or as exclusive. Would you care to comment? I'm not sure I totally understand the question, that or as exclusive. I mean, or, okay, the article or as being inclusive. So, or usually, I discourage using or language, as I think most patent attorneys would. Sometimes you have to, or sometimes it's really, whatever, use your judgment. But or means that it's this or this, and either one could be cited against you. In other words, if I say the claim is limited to A or B, if the prior art is either A or B, then it logically follows that your claim is not novel because it has A or B. So if you say A and B, and only A is in the prior art and not B, now it's novel. So I think what the question is asking is, if I write it as or being inclusive, I don't know. I have trouble with this. I'd have to think about this more. Maybe I'll think about it over a break. But if you set it as inclusive, a patent attorney can be their own lexicographer and define things as they want. I think that would be directly against the logical, what or means logically. I don't know. I have trouble understanding how it would be interpreted, because if you say it would be both things as being inclusive, if that's what's meant by inclusive, then why don't you use the word and? I think that would be easier than trying to redefine the word. I don't know. I'd love, whoever wrote this, please email me afterwards. I'd love to discuss it further, because it is an interesting question. Another question I have here just came in. One thing I have done is to import the definition of a key term into a claim when necessary. Again, would you care to comment? Yes, I think that's a great suggestion, to import the definition. Because sometimes, I actually did this in response to the office action that I'm about to file. I did it, and the examiner, and it was one of those where I didn't say defined as in the specification, and the examiner rejected it based on something that really wasn't relevant at all. He said I hadn't defined it well, and it could read on this type of process and so forth. So I actually did exactly that. I took the definition, I threw it right into the claim, and I gave a response that way. I'm sorry, this is one I did already. And it actually worked. He cited new art, but it did work to overcome the rejection by just pulling the definition in. I said, that's not what I mean. He said, yeah, well, I can say this. Well, okay, fine. So I put those words in there, rejection gone, new rejection. That kind of thing. So I think that is a great suggestion to just import your definition in. And I would add, not necessarily in the independent claim, but put it in the dependent claim. So the independent claim's rejected because he says it's this. Hey, it's in your dependent claim and you're covered. All right, so moving on, next slide. Be expansive in your application. Patent applications, you look at Thomas Edison's patent for the light bulb. I think it was 2 or 3 pages. They used to be very short. They were, today they're more like 10 pages, assuming it's, the way they print it, single-spaced, small font, that type of thing, comparing apples to apples here on the font size. They're much longer. I think a lot of that has to do with we have computers. You don't have to go to the secretary who uses the eraser stuff on the typewriter to, I don't even know what it's called. I'm sorry, that's how young I am. The stuff they use to erase what they typed on the typewriter. And I'm hearing this from an attorney I worked for who's in his 70s now, that said you go to the secretary at 4 p.m. on a Friday and you want her to change something, you need to file it, she's not going to be too happy. All right, so I'm just going to finish this slide and then we're going to pause. So don't limit yourself, be expansive. You might put in disclosure comprising of and consisting of. You might say either, because in your claim you might have to change it from comprising, which is more broad, to consisting of. So you cover that in your spec, so you have support if you need to change it. No new matter after filing, unless it's a CPA. So get it all in, as I've been harping on a lot. And don't talk negatively about the technology or the prior art. Remain positive about everything you're saying. I think that will help you go a lot further to not become argumentative, more than you need to on the legal arguments. And we're going to pause now to enter code 1.
Please take a moment to write down lawline.com's first verification code. Lawline.com's first verification code is the word cookie, all in lowercase, C-O-O-K-I-E, cookie. Please take a moment to write down lawline.com's first verification code. Lawline.com's first verification code is the word cookie, all in lowercase, C-O-O-K-I-E, cookie.
Okay, welcome back. All right, so we're on the next slide, claim drafting with the office action in mind. So this is more or less a rehash of everything I've been saying, but this all comes together now in the claims, and this is a good conclusion for this section. If you have support for variations, you'll be better prepared if the patent office finds art that reads on some of your claims. You can always amend them. And sometimes, as many of you know, the art really isn't that close, but if you can amend, then you can overcome the prior art in that way. Make your claims count, include novel variations, dependent claims. When I first started at one of my firms, I wrote this great set of claims, and the attorney, he knocked them all out. He knocked out my claim like 4, 5, 6, 7. He's like, "There's nothing new about that. Great, you're adding that it emits a sound. That's not new." And in retrospect, I was happy at the time, but I think he's right and learned a lot. You're adding a claim that it's going to be the same rejection, or it's going to be something that you could reject easily by citing it somewhere else. You want to make it hard. Make your claims count. Make them things that are really novel. You don't have to use all 20 claims. Sometimes you can't find 20 claims. You don't have to use them. But then you might fill it up with different variations and different combinations, because as you know, multiple dependent claims are very frowned upon. So you might take a dependent claim, put it twice, whatever it is. So draft your claims to what's new and obvious, but it'd be as broad as possible. I think that goes without saying. And there's two schools of thoughts on the office action. I worked for 2 different firms prior to starting my own firm in 2007. And one attorney I worked for, he would say, amend your claims. He would say, first office action, I always amend the claims, let the examiner feel like he won, feel like he got something. It's good negotiation strategy. Start with more than you want. Start with a claim maybe a little broader than you think you're going to get, negotiate down. I worked for another attorney after that, another law firm, and he said, fight. Draft your claims the way you want them, fight, fight, fight. You don't want to change it. You come up with festo issues, which just briefly is when you narrow down, the courts have said, you can't possibly have the doctrine of equivalence apply to the things that you've narrowed down. You're making it much harder for the litigators later. So, 2 schools of thought, they're both valid, and I think depending on what case it is, what type of application, I might do different things. Parenthetically, the one that said fight, fight, fight was more in telecom, and the one that said narrow down your claims was more in devices, mechanical things. So if that is a factor, I don't know. All right, we're going to go on to the next section, non-prior art rejections. So these are rejections other than 102, 103 rejections. So when you first receive an office action, so here's again different schools of thoughts. Do you send it to your client without comment or review it first? Well, it depends, but I would say in most cases I found clients want comment regardless of their sophistication level. But the sophistication level of your client might determine what kind of comments you give. For example, I have a client who is the foremost expert in a certain chemical field, like one of the foremost in the world. So I get these office actions. She knows a lot more than I do. Patent attorney can't know everything in every subject. Well, nobody can, but your inventor hopefully knows their field. Not always, but hopefully. So so in that case, I give her some comments, I explain what the rejections are, and I say, here, would you review this? In other cases, I basically say, this is what's going on, but just practice-wise, I don't necessarily give too much because, hey, I need them to pay the bills. So I'll say, here's my, here's what it's going to cost to respond. I mean, some people I know take retainers ahead of time. It's not as much of a problem. You just go straight forward. Personally, the way I do it is once the office action comes, it's 2 and 3 years. I don't want to do the trust accounting for 2 and 3 years later. So I will bill for reviewing the office action, having the examiner interview, and then again, once we've done all the preliminaries, then I will bill again for the written response. Is generally how I do it. Some clients you bill by the hour. So as I said already, how well do you understand technology versus your client, and keep your goal in mind. Respond in the best manner to get the broadest claims allowed. That's what we really want. We want a good patent. Sometimes it means lowering yourself a little and saying my client knows more. Other times it does in fact mean my client really doesn't know how to read this, doesn't care, doesn't want to be involved. He hired me to do it. I take care of it. I'll figure it out. I'll learn it. I already know it. Maybe I understand technology area better than him. I find that happens in many cases too in different technology areas. When I do telecom patents or that type of thing, which I do a lot of, I find oftentimes I'll go to a client and I'll be like, what do you mean you don't know what A&I is? That's what you do in your industry. So anyway, it happens. All right. So next slide, parts of an office action. Cover page. First thing you do when you get the office action, it has the mailing date on the cover. You use this for calculations, as you should all know already. So this is what I do. I docket the dates. Typical dates are as follows. 1 month, I'll ping the client. Personally, the way I do it, I have an automated invoice system. I send the invoice right away for the review, and 30 days, it sends them a reminder that their invoice is overdue. And then I'll get the reminder too, and I might call them up and say, what's the deal? Do you want to go forward on this? Usually it's, yeah, okay, we do, whatever it is. And then by 2 months, you should begin doing the work, if you haven't already, because you want to get in by that 3-month regular deadline. It's true, it doesn't cost that much for waiting past 3 months. I know many lawyers in general, it's just patent attorneys, will often wait till the last moment. I prefer to get stuff out quicker. That's just my personality, I suppose. And once you start waiting, you start losing patent term extension if you wait over 3 months. So that can decrease the length of your client's patent. So I try and get in by 3 months. And by 5 months, if your client still hasn't told you one way or the other, preferably in writing, because you don't want to get sued when you don't have in writing that they didn't want to respond. Incessantly ping your client, capital letters, urgent, urgent, respond. Warning, warning, that type of thing. 6 months, it's abandoned. That's it. You pay fees from 3 to 6 months, as you know. And now let's get into the office action summary on the next slide. It's not always accurate, but it does give you a roadmap. Often, at least, the bigger things are right. You may want to take the allowed claims to protect them, file a divisional for the rest. So often you'll see claims 16 and 17 are allowed, they'll ask to reject it. When you talk to your client, well, claims 16 and 17 are useful to us, so let's take claims 16 and 17, we'll file a divisional. It's true, it's extra $1,170 right now in issue fees, at least $530 in filing fees, but it may very well be worth it because you don't want them doing more search rejecting. You want the burden of proof to be on your side, your client's side, to say, hey, this is a valid issued patent. You want to talk otherwise, you go and prove it, rather than risk losing those claims. If the office is final, you need to tread with more caution. Final, practically speaking, often means you just owe the government more money. As John White will tell you in the patent bar class that I took, if you didn't know the answer to a question on the patent bar exam, look for one that has money in it and choose that one, because often the answer is you fix it with money. So be on top of your client to respond quicker, because now the clock's working against you. If filing a request for continued examination, you can treat it like non-final but pay the money. But same thing. I would try and do 3-month deadline and so forth. If you do it by 2 months, there's the added benefit of if you respond within 2 months after final, the examiner has to at least tell you if they'll accept the claims or not, and you get something of more on the record from the patent office telling you about your claims. All right. Going on to the next slide, this is just a picture of the actual front of an office action. You can see the mail date is 3/23/2011, so then your regular response date is 6/23. I bother my client right away about it. He gets an automated reminder 4/23, and by 6/23, I hope I've gotten a good answer out of him. If not, we're in trouble. All right. And then on the right-hand side, response to communication, it tells what day I filed, actions final, non-final, and you can see that there is claims 1 through 20, there's a restriction requirement, which I argued against, and we're going to go through that next, overcoming that restriction requirement. It can be done. So the next slide is on restriction requirements. Again, I'm assuming you at least have taken the patent bar exam. You know what a restriction requirement is when I talk about this. It's separating two inventions into two different patent applications, because the patent office says you're trying to patent world peace and thermonuclear warfare in the same patent application. And they say, no, those are two inventions.